new law violations, no firearms or dangerous weapons, and a no contact order.
All right, thank you.
And Your Honor, if I may just add to that, my understanding is that at least when this incident occurred, both the defendant and the alleged victim were both in custody. I expect defense counsel might have some concerns regarding a no contact order. Given that setup, state still believes a no contact order is necessary, and of course, violation of a no contact order are willful violations.
Thank you.
The no contact order is in the judge's folder.
Thank you. And it looks like the felony trial is set for the 27th of October. Ms. Griffin.
Your Honor, I would just note for the court, as you stated, Mr. Cheney is already being held on very significant bail in Superior Court, so I don't know if there's much utility in tacking on an extra $15,000 bail, which Mr. Cheney obviously cannot afford given his financial circumstances that we discussed earlier. As far as the no contact order goes, I would be curious what that means for Mr. Cheney while he continues to remain in custody. I don't know how the jail mitigates those safety concerns or imposes that no contact order, whether they have the availability or the space to have Mr. Cheney and the alleged victims in different areas. If that is possible and feasible, then I would have no objections to the no contact order, but I would just really hate for Mr. Cheney to be in a position where he's unwillfully violating the no contact order, just given the circumstances of where he's living and in custody, and this other individual being in custody as well. So I do hear the state saying that they would be looking for willful violations, but I would just like it to be on the record that I have concerns about Mr. Cheney being put in a really tough spot here, and I just don't want that to compound what he's already dealing with in terms of his legal matters.
All right, thank you.
And Your Honor, regarding a request for increased bail, if I may, this is a separate case from the Superior Court case. I have no independent knowledge of what the status is on that case or what's happening in it. This case stands on its own and should have appropriate bail imposed.
Thank you. And is the city of Tumwater making a motion to revoke based on the new charge?
Just a minute, please.
That's the theft case. That's the backup.
One moment, please.
And Your Honor, if I may, while Ms. Kittmacher is looking for that information, I would still maintain an objection to the bail on the grounds that Mr. Cheney cannot afford any amount of bail at this time, given that prior to being in custody, he was on food stamps, and now that he's been in custody, he's been out of work for a very significant amount of time, about 7 months now. So it would be tantamount to a no bail hold.
All right, thank you.
Yes, Your Honor, on the backup matters, say we'll be making a motion to revoke based on the new law violation.
All right, well, that state's motion to revoke on case ending in 764. Post bail, $5,000 cash or bond, both the assault case as well as the theft case. And I'll set a in custody pretrial based on my understanding of the very high bail that Superior Court has on Mr. Cheney, that he's likely to be in custody.
That 5,000 on each.
5,000 on each.
Thank you.
So I'll set pretrial hearing for the 4th of September. And I'll put it straight to the 1:30 calendar. And the pre-FTC will be on the same date. And I will sign the no contact order, essentially saying that Mr. Cheney is to have no contact with Mr. Wirwan, but I removed all the distance restrictions. I'm going to let the jail figure that one out. All right, Mr. Cheney, we'll see you next before this court on the 4th of September. Thank you.
Yes, sir. So
Ms. Vallejo, go ahead.
Your Honor, I believe Mr. Gary Humbach is in Nisqually.
All right.
Um,
Is that Mr. Humbach? Is that you?
Yes, sir.
Okay, we got you. Thank you.
I did get a chance to speak to Mr. Humbach earlier today. Your Honor, I've advised him of his rights and I believe he understands them. We will be stipulating to probable cause for today's purposes, and we will be requesting that Thurston County Public Defense be appointed based on the information he provided for
All right,
us.
thank you.
I'd like to also point out that his partner, Annie, is here.
Okay. That's Gary Neal Humbach.
Yes, sir.
And Mr. Humbach, you signed a constitutional rights form. Do you have any questions for me about those rights?
I haven't signed any constitutional right forms.
It says, I, Gary
They
Humbach,
haven't
have
given
read.
me- I have got
Says-
no forms to sign whatsoever.
You signed for?
On his behalf.
Okay, so Ms. Vallejo signed it for you. She indicated she
okay.
went over those rights with you.
Yes, she did. Yes, she did.
Okay, all right.
Okay.
And do you
now
have
I
any
get it.
question about those rights?
No questions at all.
Okay. Right. And what's the nature of the charge?
It is assault for domestic violence and malicious mischief in the 3rd degree of domestic violence.
And you indicated no objection, is that correct?
That's correct, Your Honor.
Well, note probable cause on charges of assault, 4th degree domestic violence, malicious mischief, 3rd degree domestic violence. And Mr. Humbach, what do you do for employment?
I am on disability since 2010.
Okay, and the 2,700 a month is disability payment. Is that workers' comp or something?
Yeah, that's Social Security, disability, and L&I.
Okay.
combined together.
And do you have a permanent partial disability or is this
I
time
am
lost?
permanently disabled, yes, sir.
Okay, all right. And no minor children living at home?
No.
All right, I will appoint counsel to represent you. Although you pay $100 up to freight taxpayer expense of providing service of counsel. And what is the state's position on release, please?
The state has no objection to PR with no new law violations, no firearms or dangerous weapons, and a no contact order. It is our understanding that the victim is here in the courtroom and they would like to be heard.
Okay, thank you. And Ms. McGoldrick, come on up. If you have a seat right here. Yes.
This was all a big misunderstanding. I did not call the officers. I did not call the cops. We were having a very loud argument in the backyard and the neighbors called.
Mhm.
And then they came in and the officers came in and fighting and we were yelling and then they arrested him. Nothing happened. He didn't hit me. I have PTSD and high anxiety, and that night I was having an episode and it might have caused our yelling and screaming accident or fight. And the officers decided to arrest Gary. And I didn't want him arrested. And we are looking into getting counseling as a couple and working this out. And I also, we do have animals in a house, and with the no contact order, it would be a financial hardship extremely for me because we bought our house together and I can't afford it by myself. He helps me pay the mortgage, and I also have 2 animals and I can't. And also, because of my anxiety and PTSD, I've had some major depression, and Gary's actually stopped me from hurting myself a couple times. And for me to be alone would be not be good for me, my mental emotional health. And that's why I really would like the non-contact order to not be signed.
Do you have any family in the area?
No, they're all in California. And I don't have anyone that could stay with me and no one to help me out with my mortgage.
Okay.
And sir, I would we would go to counseling, we would do anything we can to work this out.
Do you think you would feel safe?
Yes. Like I said, he's
Taking back
actually
the
helped me
house?
stop me from hurting myself.
All right, thank you for coming in today. And Ms. Vallejos, did you have anything else you wanted to add?
Yes, Your Honor, I will object to the no contact order. Mr. Humbach's statements to me earlier today echo Ms. McGoldrick. He is supportive of her financially, emotionally. He is aware of her PTSD and her, she would be significantly impacted if they were to have no contact.
Thank you.
Your Honor, the state would like to respond.
And let me know if there was any indication of drugs or alcohol involved.
We'll look for that now.
Thank you.
If I may respond, Woman spoke as looks for
Go
that
ahead.
information. Allegations are in this case, and the probable cause statement has been submitted to the court that the defendant hit the victim with a burning piece of a planter that had been in a fire pit, causing a visible red mark on her arm. 911 caller also reported seeing the defendant punch the victim in the face, and also that he punched the door, causing damage to the door. The city understands the alleged victim's position, but would like to underscore the seriousness of the allegations here as the reason for the no contact order to be imposed. The report does indicate that the victim was quite scared of the defendant. The third party, the neighbor, observed the alleged assault, which apparently continued for some amount of time. Perhaps most concerning to the city is that this could have been a lot more serious than it was, with the report that an object that had been burning in a fire pit was used.
And there was no indication of alcohol or drugs.
Yeah, just a minute. And Ms. McGoldrick, come on back up, please. So the two of you purchased the house?
It's in my name,
It's in your name?
but he pays, the only reason I was able to afford it is because he pays half the, or a quarter at least. I would say a third of.
He
my
contributes significantly to the mortgage payment.
Yes, significant. Yes, I wouldn't be able to do it that way.
Yeah, I am concerned about things that I'm seeing that you told the officer that spoke with you. So,
And that's what I wanted to speak with that. The officer, he did not punch me in the face. He didn't hit me with the burning stick. When I get upset, I have a scar right here that gets, around it gets red. And she was like, what's that on your face? I'm like, I don't know what you're talking about, but he did not, as you can see, I have nothing. He did not hit me in the face. And when I'm in a panic attack, I have my PTSD attack, I can act irrationally and say things. And I was not in my right mind. I was having a crisis, and I don't know what the neighbors saw. He never hit me with the stick. And the problem was, I thought that was my mom's plant holder because I had one just like it, and it was his. And he got upset because I burned it, and I didn't do it on purpose. I thought it was mine, so that's why he was upset. And he picked it up out of the fire, but he was just standing there. He didn't come after me with it. So maybe the neighbor thought that he was coming after me with it, but he didn't. And yes, I've punched doors in my own house and put a hole in before, but he wasn't trying to get in. He was just angry and he hit the door, but he wasn't trying to get to me.
and how do you deal with your PTSD? Are you doing therapy?
I have a psychiatrist. I've seen Dr. Harvey with Genuine Healthcare, and my counselor that I had retired, so I haven't found a new counselor yet, someone that can actually like talk to. But I'm on medication, and that's another reason why this might happen, was because I ran out of some medication that helps to calm me down, and my psychiatrist wasn't in the office, so I ran out and I couldn't get a refill, and so I haven't been without it for all weekend now too.
Yeah, have you gotten a prescription for it again?
Oh yeah, it's just the refills. I get so many refills, and then I have to call it in. But he happened to be on vacation when I let it run out before I got
Do you
it.
have it? Have you been
What?
able to get it yet? Or you don't have it yet?
No, because today's Monday and he'll probably be back in the office, and and my pharmacy could call him and get me a refill. And I don't know what there's up, but I am fine. I am not, he did not hit me. I've punched holes in my own doors before from being angry.
The neighbor who reported it said that Mr. Humbach hit you right in the face. He also reported that usually it's you who's hitting him, that he's seen this before. And he says you're usually the aggressive one, but this time he said it was Mr. Humbach.
I don't know whether the hitting comes in. I, I don't know. We've had some.
He didn't say hitting. He just said you're usually the aggressor, and that Mr. Humbach is usually very calm. And in this case, it was the exact opposite.
Well, we've gotten some really loud shouting fights, but there's no hitting.
How long have you been together?
For 14 years.
And where were you going to therapy? Here or someplace else? Or
No, right at Genuine Healthcare in Olympia. Dr. Harvey. That's my psychiatrist, but I don't have a counselor yet.
Right.
And actually, when I get like that, he's usually able to just calm me down. That's why they said that he's the calm one, because when I have these episodes, he's actually able to like get me to calm down. So.
That is a hard one because the allegations are pretty serious. That you were hit with something from the fire and then hit in the face.
He did hit in the face. Those are
And
not true.
On the other hand, you've expressed to me your strong desire to have him at home to help you. So he's a real.
I mean, I don't have any bruises on my face. He did not hit me in the face. I don't. And he did walk, he had the stick in his hand that was burning, but he didn't swing it at me or come after me. It might have looked like he was, because I don't know what they think they saw with that.
All right. And Mr. Umbach, thank you. I will
sir.
authorize your release today. Conditions of that release are that you have no criminal law violations, you're not to possess any firearm or other dangerous weapon. And I will not enter the protection order at the request of
Thank you, sir.
Ms. McGoldrick. But as I said, I'm concerned about the allegations as they currently stand. So I can't say much else other than, you know, if there's other incidents, this is likely to be the very first thing that happens is a no contact order going into place.
Yes, sir.
Okay, we'll see you next a week from Monday, or pardon me, a week from Wednesday at 8:30 in the morning for your arraignment on this charge, or these charges.
Thank you very much, sir. Appreciate it.
Okay, you're welcome. See you on the 20th at 8:30.
20th at 8:30. Off. Thank you.
Yes. And we'll send you text reminders of that.
Okay, thanks.
Okay. Ms. Griffin.
Your Honor, I'm here with Mr. John Ogden, matter number 1 and 2 on the calendar this afternoon. He has been advised of his rights, and I do believe he understands them.
Matter 1 and 2.
Thank you. It's John Joseph Ogden.
Yes, Your Honor.
And Ms. Griffin, did we get cell phone number?
Yes, Your Honor. There should be a screening form with Madam Clerk with a cell phone number as well as an address.
Thank you. And Mr. Ogden, you went over your constitutional rights with Ms. Griffin.
Yes, Your Honor.
Any questions for me about those rights?
No.
And Ms. Griffin, any objection, probable cause?
Your Honor, no objection to probable cause with respect to the DUI charge. However, I do see for matter number 1, there are 2 separate counts of reckless endangerment stemming from the same incident, and I'm failing to see the basis for 2 reckless driving charges.
Reckless endangerment.
Reckless endangerment, my apologies.
Your Honor, I can clarify that since I processed the amended complaint this morning.
Ms.
For-
Kimmacher.
Yeah, thank you. It's for John Ashton, is that correct?
I'm sorry,
It's John Ashton speaking of.
John Ogden.
Ogden, okay, thank you.
ACHT, yeah.
Just a moment, please. Your Honor, the basis for the 2 charges of reckless endangerment in the vehicle, the victim vehicle, there was a driver and a passenger who were both injured after being struck, I believe, head on. Basis for the 2 counts. I've requested supplemental information with their names.
Okay. I will find probable cause on all 3 counts, DUI and 2 counts of reckless endangerment. enter not guilty pleas for Mr. Octon to those charges. And Mr. Octon, you help out in your wife's company, is that right?
Yes.
Do you have any dependents residing at home?
No, I don't.
I will appoint counsel to represent you. Based on income level, I'll order that you pay $150 help defray taxpayer expense of providing service of counsel. And Ms. Bogia, state's position on release.
The state will be asking for bail in the amount of 10,000 with heightened DUI conditions, including scram, pretrial services supervision, and a requirement of an ignition interlock device. It's anticipated that defense will argue the low BAC here. It was ranging from 0.036 to 0.0038. However, this was a head-on collision causing injuries to both the driver and the passenger of the victim vehicle. Additionally, the defendant here was convicted of reckless driving, which was amended from a DUI, and it was completed on July 28th of this year. And now he's here again with a DUI, and the state has significant public safety concerns.
Just to clarify, the conviction was entered on the 28th.
Thank you. So this is a second DUI in a matter of 5 months, 6 months, something like that. 7 months. Is that right?
Yes.
And I'm getting the information for the conviction date from the plea and sentencing tab in JABS.
State down in NCIC.
Yes, Your Honor.
Thank you.
One moment, please. No additional DUIs, the state observed on there.
Are there felony charges in this case? State's not charged vehicular assault?
Not at the moment, Your Honor.
I mean, I'm assuming what I'm looking at here, I'm inferring, because I don't have a police report, is that Mr. Octon was going one direction or the other on Yelm Highway and ran a red light and struck a victim vehicle. Is that what happened? See it, Yelm Highway and Rich Road, so that's not a common occurrence, but a high risk area.
His vehicle was towing a boat, went head on with an SUV. His vehicle was facing eastbound on Yelm Highway Southeast, the wrong way in the westbound left turn lane to Rich Road Southeast. It was completely in the oncoming lane at its final point of rest with the SUV.
And Ms. Griffin, anything else?
Would you like to hear my objections to the state's conditions at this time?
Yes.
I would be objecting to the $10,000 bail at this time, Your Honor. Mr. Ogden's wife is the sole income earner for their family, and after living expenses, he and his wife do not have much left over between themselves, so it would be very burdensome for them at this time to have to pay a bail of that high amount. I would also note for the court that Mr. Ogden's Warrant history is extremely old. He is somebody who comes to court. He lives locally. He owns his home, doesn't plan on moving anytime soon. We do have updated contact info with the court. That all to say that he would not be a flight risk. We also understand that the state has concerns with respect to community safety, and we do believe at this time heightened conditions, including the ignition interlock device, the scram device, and reporting to pretrial services would be enough to mitigate those community safety concerns. So again, I would just be strongly objecting to that $10,000 bail amount, asking that Mr. Ogden is released on his personal recognizance and he would comply with those heightened DUI conditions at this time.
Thank you.
Oh, you can't even.
Is there a breath result or a blood draw? What's the story here?
The PBT was 0.064, VAC was 0.036 to 0.038.
Is there a blood draw?
No, Your Honor, that's the BAC, the state's proceeding on effective 5.
On 0.003s?
Yes, Your Honor, given the severity of,
Right, no, I understand the nature of the accident. You still have to prove a DUI.
understood.
Okay. All right, I'm looking at the judgment and sentence conditions from the Pierce County DUI that were imposed on the 28th of July, just prior to this accident, which reflects no criminal law violations. Clearly, that's alleged to have been violated. And no consuming alcohol. Which that appears to have been violated based on the fact that there is some alcohol showing up in the breath readings. Given those factors, the apparent violation of court orders issued just a few weeks prior, and the very serious nature of the accident in this case, I do think bail is warranted here. I'll make bail $5,000 cash or bond on the DUI, $10,000 cash or bond on the reckless endangerment due to the injuries to the passengers in the oncoming vehicle. Mr. Ogden, if you post the bail, no alcohol, period. And you were told that in Pierce County, and now you're being told again, none, 0, may not have it. You may not enter a bar. You're not to refuse any breath tests. Don't drive unless you have valid license, insurance, and ignition interlock in any motor vehicle. You're to obtain a scram alcohol monitoring device within 48 hours of release if you post the bail, and report to pretrial services within 48 hours of release if you post the bail. I will make you eligible for the county funded program in that regard. You know, a head-on collision is something we're not going to take lightly. So you got to do this the right way the whole time. All right, I'll give you a pretrial date here in a moment.
So 15.
What time on the 3rd of September? Well, let me ask Ms. Griffin, find out from Mr. Octon, is he likely to post bail or not? If he's not, I'm going to put him on the 1:30 calendar. If he is, then I'll give him a out of custody date.
Your Honor, I do believe that Mr. Octon is going to post bail.
Okay, thank you. All right, and Mr. Octon, you're due back before the court on the 17th of September at 9:30 in the morning with all those conditions having been imposed. We'll see you then. Thank you.
Your Honor, I believe there are additional in-person dismissals for talks DUIs, if we could address those.
Just a moment.
I'm not sure if defense has already released them.
Okay, off the 1:30 calendar dismissal. Or pardon me, the 1:35 calendar.
Yes. Douglas Evans. Number 1 on the 135 calendar.
Okay, both cases.
Yes. The state is moving to dismiss without prejudice pending talks.
Okay. Mr. Evans, you want to activate your audio for me, please? Click on the microphone. Should be down at the bottom of the screen.
Your Honor, I apologize. Were you speaking with me?
No, thank you.
There you go. Can you hear me now?
I can, thank you. All right. And the state's motion applies to both cases. Did you indicate that?
Yes.
Okay, thank you. Mr. Evans, 2624 Aberdeen Avenue.
No, Your Honor. I gave them my current address when I posted bail.
Okay, how's the mailing address of PO Box 41140? Is that still a good address?
I've never had that P.O. box that I remember.
Okay, well, that's the one that Department of Licensing has to send you all your mail. So my guess is you never get mail from the Department of Licensing because that's where they have you sending the mail, and then they still have you living at the address on Aberdeen Avenue. So the reason I point this out is the law requires every time you move, you have to notify the Department of Licensing with your new address, and you can't do it by telling me or telling a officer. You have to actually go into one of their offices or go online and their website and change the address. You have to do it yourself, so we can't do it for you. So why don't you give me your current mailing address?
It is 1324 North B Street in Aberdeen,
And what's the zip there?
98520.
Okay, thank you. And that's going to be important because I'm granting the state's motion to dismiss the charges of driving under the influence of intoxicants, possession of a controlled substance, and legend drug, all three of those counts. Now, without prejudice means they can be refiled, and the prosecutors indicated they're waiting for the results of the blood draw that was taken in this case. That'll take up to a year to get the results back. So once they have the results, then they'll evaluate your blood results and determine whether they're going to refile these charges. They will have the right to do so if they have evidence to support them. And if they refile them, then we'll send notice to the address that you just gave us
Okay.
to reappear in court. If that address changes, make sure you keep Department of Licensing and the court advised as to a current address, okay? So we can get in touch with you if the state decides to refile the charges.
Will do.
Okay, for now they're gone and I'm signing dismissal orders on both. Thank you.
Thank you. Thank you.
Yep. Ogden.
I believe there's a couple.
They're gonna
Okay, another dismissal on the 135 calendar.
Yes, Jeffrey Jonathan.
All right, Jeffrey Jonathan. Don't see Mr. Jonathan present. And Ms. Vallejo, was Mr. Jonathan present that you know of?
I am not aware yet.
Okay. He misses the opportunity to see his case dismissed and understanding what it's about, but I will grant that motion to dismiss. Those are the dismissals.
There's one more.
Yeah, one more.
Okay, go ahead.
Kyle Zion.
Okay,
The state is moving to dismiss this one without prejudice. We're waiting on the report. It appears to be talks, but we don't have a actual police report yet.
He was here earlier and Ms. Bay was let him know.
did you happen to confirm his address?
I don't know.
Okay. All right, I've granted motion to dismiss without prejudice on the DUI charge.
I think that's all the out of custody ones.
Okay, and Ms. Griffin.
Your Honor, I'm here with Mr. Feded. He is matter number 6 on the calendar this afternoon.
All right, it's Juan Amable Ferrer. Is that correct?
Can you hear me?
I think so. Can you hear us, Your Honor?
I just barely heard that, but I think I got a confirmation.
Yes, sir.
And it looks like we have an address and a phone number. And Mr. Ferrer, you had an opportunity to go over your constitutional rights with Ms. Griffin, is that correct?
Yes, sir.
All right. Any questions for me about those rights?
No, sir.
And any objection to probable cause today, Ms. Griffin?
No objections to probable cause today, and we would be entering a not guilty plea.
Thank you. Well, no probable cause. Well, I think we're at a no, we're at arraignment. All right, well, no probable cause on a charge of assault, fourth degree domestic violence, enter a not guilty plea for Mr. Ferre. Is that how you say it, is Ferre or
Ferre.
Ferre? Ferre.
Close enough, sir.
Okay.
25 years in the military. I've heard it mutilated a million times. It's okay.
Yeah, I get it. All right, I'm gonna try to roll the R's and get it right. Ferre.
Appreciate it.
Okay. All right, enter not guilty plea for you, and you're gonna hire an attorney or not, or ask me to appoint an attorney?
Your Honor, I would be asking that Thurston County Public Defense is appointed at this time. Mr. Fede is on disability. He is a veteran who receives disability from the VA hospital.
All right, thank you. I will appoint counsel to represent Mr. Fede. And this appears to be a first such offense. Does the state agree?
Yes, that's correct.
And state's position on release.
The state has no objection to PR with no new law violations, no firearms or dangerous weapons, and a no contact order.
Thank you. And Ms. Griffin.
Your Honor, we have no objections to those conditions. I think the no contact order may be important to revisit at some point in time, but at this time, no objections.
All right, thank you. Any indication of drugs or alcohol involved?
Was that tough?
No, it's not to you. Go ahead. Custody pretrial date on TV calendar.
No indication of alcohol or drugs.
Thank you. Thank you. All right, Mr. Ferre, I will authorize your release today on your own recognizance. Conditions of that release are that you have no contact with, I'm assuming that's your wife, Graciela,
My
is that
daughter.
correct?
My
Your
daughter.
daughter? All right. Are they it's all one person? I'm assuming Aurora Lynn Graciela, or are they two people?
Yeah, that's one person. That's my
Okay.
daughter.
Okay, I thought I heard you say the plural, so I want to make sure. Okay, no contact with your daughter until otherwise authorized by the court. You're not to possess any firearm or other dangerous weapon, and no criminal law violations. Your next court date is Wednesday, the 3rd of September at 10 o'clock in the morning. And we'll mail notice to you and send notice to the cell phone number that we have for you.
Yes, sir.
Okay. If not resolved on that date, we set it for trial. So it's going to be important that you reach out to Thurston County Public Defense well prior to the 3rd of September. Find out who your attorney is.
Yes, sir.
And make an appointment to speak to that person prior to that date so that you're ready to let us know how you want to handle the case.
Yes, sir.
Okay, we'll see you on the 3rd. Thank you.
Thank you, sir.
You're welcome. What else?
Your Honor, I do believe Miss Heather Mayo was sitting in Nisqually, but there she is.
Okay. And it's Heather Renee Mayo.
Yes.
Thank you, Ms. Mayo. Good afternoon. And And probable cause was previously established. The charge of possession of controlled substance, enter a not guilty plea for Ms. Mayo to that charge. Ms. Mayo, we missed seeing you at your arraignment on the 4th of February. What's the story there?
I was beaten and raped.
Say that again.
I was beaten and raped.
Okay.
Then I just kind of just lost it. I was in the jungle.
Okay. All right. Are you working?
No.
I'll appoint counsel to represent you. State's position on release.
The state is requesting bail in the amount of the warrant with no new law violations, no alcohol, marijuana, or non-prescribed drugs.
And Ms. Vallejos.
Your Honor, Ms. Mayo has experienced what she shared with us, with this court. Experienced it then, has experienced it recently, is dealing with the aftermath of those events. She is currently unhoused. Any bail amount at this point is the equivalent of no bail, a no bail hold. I request and I object that object to any bail amount and that she be released on her own recognizance, Your Honor.
Ms. Mayo, if I let you go, do you come back?
I promise I will.
Okay. How are you going to keep yourself safe?
I'm gonna try.
Okay. I can say with a high degree of certainty that using doesn't keep you safe.
It doesn't. I want to go to rehab.
Your Honor, it looks like there are additional new law violations.
You're right.
in the-
I'm just about to discuss that. Ms. Vallejos, did you go over the new charges with? And are we prepared to do an arraignment on those today so we don't have to set a separate hearing?
Your Honor, oh, sorry, go ahead. Oh, I don't think they're even entered into our system at this point, although I'll check if it
I have a
was
case
done
number.
in the meantime. One moment, please. I don't have the police report in front of me, so that was mostly what I was inquiring, if another arraignment date had already been set.
Not as of yet. Okay, and so if you don't have a report, I'm pretty sure Ms. Vallejos doesn't have a report.
I would think
The
that's
report is up, Your Honor. I
Oh.
did read it
Okay,
fairly certain.
they are faster. I don't have it in front of me.
okay. I'm trying to save Ms. Mayo from having to come back on a second date.
Understood. I tried to get it in there ahead of this calendar, but it's too late. Looks like those are only from this past Friday, so that makes sense.
The possession charge or the possession report?
I don't have the report in front of me for the charges from August 8th on this past Friday.
Yeah. I have a wedding at 5, but other than that, as long as we finish here.
My apologies, Your Honor. These are from the last charge, the possession charge that I was reading. It's not from the this
Oh.
last one.
Okay, it's not the August 8th charge.
It is not.
Okay,
No.
all right. So that was a noble attempt to try to deal with your newest case today, but we're not going to be able to do that, Ms. Mayo, because nobody has the police statement. So it's criminal trespass, second degree, it's use of drug paraphernalia and possession of controlled substance. Those are the charges I see, but right now we can't proceed on them because nobody has any information on them. But you will likely have to appear back in court on those once that report is with the attorneys. And do you have a cell phone?
No,
Do you ever get one of the cell phones? That,
it was stolen.
okay.
Uh,
And have you gone to get another one?
Yeah, I'm working late on it, methadone clinic.
If you have a cell phone and give us this number, then we can text reminders of hearings.
Okay.
You know, if you're still moving around without a firm address, then mailing you doesn't do any good, but
Right.
the texts come in helpful, obviously, if you're not in one place.
Yeah, as soon as I get it, I can give it to you guys.
Okay. All right, I'm gonna let you go. I want you to clear that Olympia warrant. Pardon me, yep, Olympia warrant on the theft case, which is pending, so you're gonna need to work that out. And I'm gonna take you at your word that you're gonna come back to court.
Okay.
Okay, so no drugs or alcohol, you know that.
Mm-hmm.
And the people who provide those are probably the people who are causing you a lot of harm. So
Yeah.
you're gonna have to figure that one out.
Okay.
Coming back on the 17th of September at 10 o'clock in the morning.
Okay.
And the jail's going to give you a document that has this information. I'm signing it now, and the jail's going to give you a copy of that.
Thank you.
Don't lose that, because right now that'll be your only notice, and I'll expect you back. And if you don't show up, then I will issue a warrant for you, and then you'll probably be sitting in jail until we get this case handled. So
Okay.
I'm going to give you a shot to walk back in on your own on the 17th of September.
Thank you.
Okay, thank you. Bye-bye. And Ms. Griffin.
Your Honor, I'm here with Mr. Jonathan Hand. He's matter number 11 on the calendar with 9 and 10 on there listed as backups.
Thank you. Mr. Hand, good afternoon. These are all post-disposition matters. And the DUI was from 2024. Plea being entered in that in August of 2024. And then subsequent to that, in January of this year, we have controlled substance conviction, theft conviction. And there is a backup on the vehicle prowl that preceded the case here. So that wouldn't be a violation, but the conviction on the controlled substance and theft charge would be. Is there a stipulation to that violation? Case ending in 8866.
I'm not sure if I'd be comfortable making a stipulation at this time, Your Honor.
You can just ask Mr. Hand if he was indeed convicted of those things. We have on the DUI, the amended DUI that was entered in August of 2024, and then we have showing a conviction on January 17th of 2025, which of course would be a new law violation. So unless he has a real good reason why it's there, then I'm going to note it as a violation.
Your Honor, Mr. Hand has communicated to me that the information regarding those convictions are true and accurate.
Okay, thank you. And I'll note that violation. And let's see, we have treatment issues apart from the law violation. We do no proof of evaluation. Or victims panel. Noted back in March. Warrant's been outstanding since May to talk about those. Ms. Griffin, where's Mr. Hand on the treatment requirements as a result of the Neg 1 conviction?
Just a moment, Your Honor. Your Honor, Mr. Hand is in the process of completing those treatment requirements.
Okay. What does that mean, Mr. Hand? Does that mean, okay, now that I'm telling you, you need to do it, you're going to commit yourself to it, or does it mean you've already made appointments? What does it mean?
I've already made appointments to make sure they were done, and I've been wanting to get this off my case, off my shoulder. I'm gonna have to deal with it.
So do you have an appointment scheduled for anything?
Yes.
Tell me about it.
So I have an appointment. It's the Thursday of this week, and it's basically to basically for the to get me a bed date for get inpatient treatment.
Who is the appointment with?
It's with Northwest Resources.
Okay. And that's going to be called an evaluation. So that's the first step. Okay. All right. We'll note the acknowledgement that to date, there's been non-compliance with treatment. But Mr. Hand is indicating he wishes to begin to comply.
Yes.
Okay. You know, originally you were given until November to do that, but here we are in the following August. So clearly not timely compliance, but you're starting in the right direction.
Yes.
And I'm assuming the state's not arguing that the subsequent conviction in this case is a automatic mandatory 30 days on an amended neg 1 conviction.
Just a minute, Your Honor, please.
Seat me here and we'll get to the court.
I'm sorry, can you repeat the question, please?
We have a subsequent conviction to the neg 1, which is from an amended DUI, and the subsequent conviction is for controlled substance possession and theft. And I have noted the violation on that. So what's the state's recommendation?
For a sanction or
For sanction. Okay. We've noted violations on treatment and the new conviction.
Just a minute, please, Your Honor.
Trust me, Mr. Gillum, we'll get to you. I know you're out there.
Sorry, Your Honor, there's just some confusion to me as to whether you'd already been sanctioned for a new law violation. The state would ask for 60 days in custody and to keep the case open. The state's understanding he has not done his affirmatives, new law violations. He's been on probation for the DUI amended down to neg 1 for a while, and has had opportunities for extensions to get affirmatives completed.
Like Mr. Hand's been in custody since the 17th of January, and then he was out of custody at some point after that. And I don't know when that occurred. Okay, actually, it does look like Judge Wilcox imposed a sanction on the new charge. Did that in February, subsequent to the new charge.
It's already been sanctioned for the new law violation.
That's what it looks like. Dated February 12th, 2025, 30 days in custody. Okay, so that resolves the issue of whether there's been a sanction for the new law violation. It clearly has. So that is just the ongoing treatment noncompliance. Give me a pre-FTC date in 6 weeks. Early morning calendar. Thank you. On what, September 25?
Yeah.
Okay, thank you. All right, I will appoint counsel to represent Mr. Hand on this issue. And I've set a sanction hearing on the issue of treatment compliance, for which I've found a violation because it clearly hasn't been done up to this point, but Mr. Hand indicates he's going to make efforts to try to get it done. So I'm going to release Mr. Hand from custody, and you're coming back to court on the 25th of September at 9:30 in the morning. And what happens to you depends in large part about how much progress you have made in getting the evaluation. If you go into inpatient treatment or outpatient treatment, completing the victims panel, which you can do at the City of Olympia on Saturdays. It's a 4-hour class, so there should be no reason you don't get that done. So we'll expect to see some significant progress from you by the 25th of September. And why don't you tell me your cell phone number while we have you here to make sure you get text reminders of this.
My phone number is 360-338-1890.
Thank you. Okay, you'll get text reminders of the hearing date and your obligations, and we'll see you back here with an attorney on the 25th of September. Thank you, Mr. Hand. And Mr. Gillum, good afternoon.
Good afternoon.
It's Daniel T. Gillum, is that right?
Yes, sir.
All right, thank you. Did you have a chance to go over your constitutional rights with Ms. Vallejos?
I did.
Any questions for me about those rights?
No, sir.
And 4715 Northeast 110th?
Yes, sir.
And did we get a cell phone number, Ms. Vallejos?
We did, Your Honor.
Okay,
If I may approach.
of course. And you're 17, right?
Yes, sir.
Okay. Starting your senior year?
Yeah.
What high school?
I'm not currently in high school. I'm working towards getting my GED.
Okay. Keep working at that, because if you don't, just keep working at it. It's really important to you, or should be really important to you. Okay, This appears to be a first such offense. Does the state agree?
That is correct.
I will appoint counsel to represent Mr. Gillum. Mr. Gillum, you working this summer?
No, sir.
How come?
I haven't really been able to get a job. Well, I've applied, but nobody hired me.
Okay. Schooling might play a role in that, just heads up. But, you know, I'm pretty sure if you were motivated, there are jobs out there for you. You know, people are going to hire people to do work. So if I were you, I'd get out there and do that. You seem entirely capable to me of earning income. So I'll appoint counsel, but order that you pay $25 up to for a taxpayer expense of providing service of counsel. And I'm going to set a new court date for you on this DUI. And that'll be the 17th of September. Still at 10? Okay, at 10 o'clock on that date. And you can appear remote like you are today, so you don't have to come up here for that. But I strongly suggest that you call Thurston County Public Defense sometime this week. Find out who your attorney is, make an appointment to speak to that attorney so that when you show up on the 17th of September, you can tell us how you want to handle the case. If it's not resolved that day, we set it for trial, and you will have to come up for trial.
Yes, sir.
Okay, you got that?
Yes, sir.
Okay, so in the meantime, as you know, 17, you're not allowed to have alcohol, but no alcohol, no marijuana. You're not to enter any bar or tavern. Don't refuse any breath tests. Don't drive unless you have a valid license and insurance and have no criminal law violations. We'll see you on the 17th of September. Thank you.
All right.
Ms. Griffin.
Your Honor, I'm here with Mr. Damian Madison. He's matter number 17 on the calendar, and I believe Ms. Vallejos is present in the courtroom to handle his matter this afternoon.
Thank you. Mr. Madison, good afternoon.
Afternoon.
I see it says a plea, but I don't have a plea form. Yes, Your Honor, I'm covering for Attorney Pazderka, and this was, he did get information today regarding the offer. He hasn't gone over it with the client yet. He will be in to see him tomorrow morning, so he's asking to reset this for tomorrow.
Okay, let's see where we're at. Okay, so today is actually a jury trial day, or tomorrow is too. Was this continued today at the courtroom 4?
I don't have any notes indicating that. I just see last, or on August 1st, state's notes indicate that it says striking the panel and setting for a change of plea
Right.
on August 11th.
Can you see that? Okay, tomorrow is the trial date, so we can put it on tomorrow afternoon at 1:30. Mr. Madison, we'll see you tomorrow afternoon at 1:30. Mr. Pazderka should be speaking with you prior to that date or prior to that time tomorrow to go over a plea form if that's still what you intend to do.
Yeah, I'm not aware of anything that's going on. I haven't been contacted by him, not once.
Okay. Ms. Vallejos, if you'll let Mr. Pazderka know that Mr. Madison said that.
Thank you.
Okay, yeah, we'll put you on for that tomorrow, and if for some reason that's not going forward, then we'll have to deal with that then. All right, thank you, Mr. Madison. Yep.
Yeah.
And Ms. Vallejos, do you have any others?
I believe Ms. Griffin can speak to Mr. Byron Rake.
Yeah, so I'll ask Ms. Kitmacher, since we set this over for that purpose. What are we doing on Mr. Rake today?
As far as where Miss Milne is and where he is specifically, I'm not sure. You had asked me to reach out to Western State and figure out when, once an order is signed, they would actually get him there. I was able to figure that out this morning. I spoke to someone on their admissions team who indicated that she can't give me a specific date of when they would, after an order is signed, they would admit him to Western State. However, they are currently at under 7 days. 7 days or under is what.
So they think it will be less than a week.
Yes.
Okay.
I asked if they could be more specific and they said no, and that the time does fluctuate, but that once an order is signed, at this point, they're working with about a 7-day turnaround.
Okay.
But that it fluctuates based on emergency entries and whatnot.
Thank you. I had made a finding at the hearing on Friday that in this case restoration was appropriate.
Ms. Milne did sign that. The only thing I did see is that it didn't look like she checked off that defense wanted to be notified of the evaluation at the end of the restoration period. I reached out to her to ask if that was an oversight. I didn't get a response, so but that's what she signed. The defense attorney present section is what I'm referring to.
Right. Yep. I'm not gonna check that. So, Ms. Milne wants to do that. She'll have to work that out with Western State. So I have signed the restoration order based on my prior finding. I am going to sign a judgment and sentence, which sets a hearing for next week. And as I made clear last week, my discomfort in holding somebody while awaiting restoration. So I'll set a hearing for Tuesday afternoon. It does not need to be me that hears it, but I will make very clearly that if Mr. Rake is still in custody next Tuesday, so the 7 days or less should have been effectuated by then, that I would release Mr. Rake. And let's put that in the docket. That if he has not gone to restoration by Tuesday, he's to be released. And then it will be an outpatient restoration, and that'll be all kinds of problems. I'll set that straight to 1:30. Setting it as a review. So for purposes of this case, we're still in competency stay from a speedy trial standpoint. And I've set a hearing for Tuesday at 1:30. All right. And it's Justin Donald Larson, is that correct?
Yes, sir.
Mr. Larson, good afternoon.
Good afternoon, sir. Yes, that's me.
Yeah, Mr. Larson, did you have a chance to go over your constitutional rights with Ms. Griffin?
Your Honor, Mr. Larson reviewed his constitutional rights this morning with Ms. Vallejos.
Now I see why you guys are double teaming me. Okay. Do you have any question about those rights you discussed with Ms. Vallejos?
I don't believe
Mr.
so.
Larson?
I don't believe so.
Okay. All right. I mean, if you do have questions, you can ask me and I'll try to answer them for you.
I'm just confused overall. This is my first time, sir. I ain't trying to be rude. I just never dealt with this.
Yeah, I know, I understand. Okay. So I'll assume you know the constitutional rights. As questions come up, we can discuss it. Is there any objection to probable cause, Ms. Valles?
This is Ms. Griffith's case, Your Honor. And may I also point out that
Wait,
Ms.
so you went over the constitutional rights, but Ms. Griffin's going to do
Yes, I
the case. Okay. And the protected party, or this
Correct.
is Ms. Lanier?
Yes, she's here.
Okay. All right. Ms. Griffin, ball's back in your court. Any objection to probable cause?
Your Honor, we will stipulate to probable cause for the purposes of this hearing only, and I do see no charges filed at the moment, so we will refrain from entering any type of plea today.
Thank you. And the nature of the charge pursued by the state is?
Assault in the fourth degree domestic violence.
Well, no probable cause and a charge of assault, fourth degree domestic violence. And Ms. Griffin, is Mr. Laird seeking appointment of counsel or?
We are requesting the
Larson?
appointment of Thurston County Public Defense. Your Honor, I do believe that Mr. Larson makes a good net monthly income, but as you'll see from the screening form, that after expenses and a decent amount of debts that he is taking care of at this moment, a public defender would make the most sense for him financially, and I do believe he qualifies.
Thank you. Do we have a screening form? What do you do for DOT?
Highway maintenance worker. I was supposed to report to work at tonight.
Okay. And do you have any children?
No current children. I have 3 dogs, 2 that are rescues and have separation anxiety issues that me and my wife have to counterbalance and work together with.
Okay. I will appoint counsel to represent you. I'll order that you pay $250 up to freight taxpayer expense of providing service of counsel. And state's position on release.
The state is asking for 5,000 bail due to the facts of this case. The defendant hit the victim with a blunt object. There was a metal bat found at the scene causing injuries to her left knee and ankle. Law enforcement noticed visible swelling and observed her in observable pain and had trouble walking, along with scram due to alcohol being involved. No new law violations, no firearms or dangerous weapons, and no contact order.
Thank you.
And Your Honor, the victim or the alleged victim is here in person, would like to speak.
Yes. Ms. Lanier, come on up and I'll hear from you in just a moment. You just have a seat there. So I'm going to read the police report first and then I'll hear from you.
Excuse me.
So this was initially referred as an assault too, and your office made a decision to proceed on assault 4, is that right?
That is, well, go back up the notes.
Is there some concern about
Your Honor, that's the state's understanding. I don't have the details on why it was not proceeded on as a felony.
I mean, there are very conflicting stories here.
Understood. I did read the report. Actually, I'm getting information now. I believe it was downfiled from felony due to not having medical records back.
All right. And so the state's seeking a no contact order for Ms. Lanier. This is a little dicey, Ms. Lanier, because Mr. Larson indicated to the officers that you assaulted him. And you're here, anything you tell me is being recorded. The state has made a decision so far to charge him with assault, but that doesn't mean they can't change their mind and decide maybe he's the victim and charge you. So I'm telling you that, not that I know that that's what they're planning on doing. I'm telling you that so you understand you're being recorded. Anything you say could be used against you, and you might want to be careful about what you say, understanding that they could turn around and charge you. Okay, you understand that? You have any question for me about that?
I understand. Thank you.
Okay, is there anything you wanted to tell me about the no contact order?
I just think it's, I wrote this, but I just think it's completely unnecessary. My husband has never put his hands on me. The bat being brought into question was because they asked me about it, and they asked if there was one in the house, and I said yes. I brought it to them, and then they asked me if he hit my leg with it, and I said no, because he didn't hit my leg with it. We were arguing, and it just escalated, and I'm not sure who called the cops. I'm assuming it was him who called. My knee injury that was reported upon was from me falling due to trying to receive my phone back from him. But throughout the whole ordeal, he never put his hands on me. It was really just an argument that escalated to him leaving the house. And then next thing I know, the cops are at my door, and I really just, I don't agree with the charges at all. I don't agree with the no contact order. It would just be detrimental to our family and our household, and in reality, my mental health. I mean, this is my husband. We've been together since we were 15. We've been married for 10 years. This is just really a misunderstanding that has been, in my opinion, blown way out of proportion. And I don't think cops should have ever even been involved. And it's unbelievable to me that it's gone to this point.
Well, it sounds like Mr. Larson called the officer, or called 911, but also so did a neighbor. So there were two different calls based on their concerns. So that's how it came to their attention. And two of you do not have children,
No, we have,
but you have dogs.
yeah, we have a whole household. We own a house together.
And do you work?
Yes, I work.
Okay, what do you do?
I'm a lead merchandiser for a plant company.
All right, and Ms. Griffin, anything else you would like to say?
Your Honor, I would object to the $5,000 bail amount at this time. And what I would like to highlight for the court is that Mr. Larson does not have any criminal history. He lives locally, and we have updated contact information, and due to the lacking criminal history, he obviously doesn't have any warrants or failure to appear. It does sound like from the police report that there's an allegation of drinking. I think at the very least, scram device at this time would be sufficient to mitigate the state's community safety concerns. However, along with my objection to the $5,000 bail, I would also echo what, I did not get her last name, but I would echo Ms. Lanier. I would echo what Ms. Lanier has shared at this time and object to the no contact order. It sounds like Mr. Larson has been going through a hard time personally. He lost his brother very recently and is dealing with an immense amount of grief. I think displacing him out of his home, which the no contact order would effectively do, would cause a lot of undue hardship at this time, and additionally would make paying bills and managing the home and managing the animals that they have together very difficult. And again, I would echo what Ms. Lanier has shared with the court. So at this time, we would be asking for a PR release, and at the very minimum, I think Mr. Larson would be happy to comply with the scram device to keep the drinking out of the picture for these two parties.
All right, thank you.
Goes for that.
Mr. Larson, I'm not going to hold you on bail based in part upon the dispute over who was wielding the bat, if either one of you was. It's unclear. I believe the original charge of assault 2 was based solely on the fact that the officer believed you were hitting your wife with a bat, and there seems to be some indication that perhaps that wasn't the case. And I suspect the state's request for bail is based in part on the belief that you were doing that. In my mind, it's not quite as clear. And Ms. Lanier said she was never hit by a bat. So I'm going to authorize your release on your own recognizance. I am, however, going to order that you have no contact with your wife until I say otherwise. You're to have no criminal law violations. You're not to possess any firearm or other dangerous weapon. No alcohol, no marijuana. You're not to enter any bar or tavern. And you are to obtain a Scram alcohol monitoring device within 48 hours of release. So by close of business on Wednesday, you need to have that device on. And I want you reporting into pretrial services by close of business on Wednesday.
Your Honor, I understand that you've are and have made a ruling at this time, but I'm curious if because the court is imposing the no contact order, the court would be willing to forego the Scram device at this time, or if you believe that both are necessary at this moment.
I think at this point, both are necessary. I'm going to set an arraignment date for Mr. Larson for Wednesday, the 20th, and both of these issues can be revisited on that date. So Ms. Lanier, you're welcome to come back to court on the 20th. There'll be another hearing and you can make your pitch then. But at this point, I'm going to enter the no contact order. All right. Thank you, Mr. Larson. We'll see you on the 20th at 10 o'clock. And I'm sorry, at 8:30. Thank you. And I didn't, I don't think I signed any. Did I sign both other orders on hand? Or and do I need to? I don't know if he's held on those or not. I don't see the order still in my PDF. So I need those back. Let's see. No, on the theft, there's, oh, it's a release. So I need to sign that release. And then I'll need the hand. One's back.
And Your Honor, I do believe that's everything I have for you this afternoon, unless you need something from me.
It is everything you should have, otherwise we're both in trouble.
CHP swapping out the primary unit once again. Now a brand new unit right behind him here as he starts to weave through traffic. 3 units total of complete pursuit package as he prepares to possibly exit the 60 freeway coming up. Coming up on 7th Avenue, reportedly 2 people inside of that car. Again, appears to be an older model Toyota Corolla. Once again, if you're just joining us on abc7.com and our ABC7 streaming apps, Chris Christie up in Air 7 HD with a CHP pursuit crossing into LA County. This all started in Riverside County Sheriff's Department, handing this off to CHP just a few minutes ago. Now 3 units right behind him as he refuses to pull over. Reportedly 2 people inside of the silver Toyota Corolla wanted for grand theft. And you see that nice sun from above. That is compliments of the LA County Sheriff's Department helping out here, trying to light him up, but he is refusing to pull over. In fact, he is all over the pavement, hovering between 70 and 90 miles per hour.
What I was bamboozled.
Transitioning.
Good afternoon, Your Honor.
Rose, good afternoon. And Ms. Viejos, good afternoon.
Good afternoon, Your Honor.
What up, guys? So I pulled the trigger a little bit early because I thought there was a police chase, but it looks like that was incorrect. Next court doesn't start until, what time is it right now? 4:36. What up? What up? Hey, what up, Bobby Hill? Where you been at? Let me see who else. Who else is in here? Let's see. Hey, thank you, Bobby Hill. Hey, what's up, Lydia? Highly appreciate you. What up, Molly? What up, Nikki? 90. Patricia. El Taco Vato. What up, Linda? Highly appreciate you guys. Let me turn this back on over here. Hey, what up, Maui? What up, Hector? I want his number. Bella. She wants whose number? Let me see. Let me see. Happened not too far from me, right by where I go to Costco. Let me see here. Hey, let me see. The guy in LA got away. Those 2 fools got away last night? Damn, son. It's in the game. Let me see. Watching the protests outside MDC. They're still going on? Toasty. Let me see. What's good? What up? Hey man, I just woke up from my nap. I needed to take a daily nap today because I woke up really early today. Chad, what's up? Let me see. Hola, James, ¿cómo ha ido tu tarde desde que... Man, yeah, as soon as I got up, I went to take a nap. Hey, what up, Rosie? Welcome back. 24/7. Court's in session. Shit, courts is about to start in about 20 minutes or so. I was checking if there was any courts available right now, but nah, it's already 4:38. Ain't no courts going on right now. James, we can't hear the fan. Well, I need a fan. Shit, I need to stay cool up in here. I think the microphone might not be plugged in correctly. What about now? Carson, is that better? Let me see. Yeah, I didn't watch the case, but I did see it on the news today. Those guys got away. Oh shit! Who's paging me? Is that you, Chad? See, we got a page. Who's paging us? Let me see here. Let me see. I'm pretty sure this is gonna. I could already see this annoying my wife. Like, who's paging you? What are you talking about? Let me see here.